So Blake Lively's fee motion, which included a request for fees and costs in the amount of $8 million, was less of a fee motion and more of a ransom note. I was not expecting that, as I explained when her initial request came out. I was not expecting that to be that overblown. I thought she would ask for $1 million, maybe $2 million, and that would be overblown. But she asked for $8 million, and I was like, well, I never stop underestimating people, I guess, right? But if her request were any higher, I think the FAA would have required a flight plan. So it's pretty bizarre. This woman has tried every avenue possible to circumvent people's rights, to abuse the legal system, to violate people's privacy. It's crazy. And she tried to settle her case and then use that as a runaround to have the judge rule that she was entitled to a whole bunch of money from Justin Baldoni and the Wayfarer parties related to this countersuit without their, they have a right to a jury trial. But she thought she could get around that. She thought that she could take them by surprise with the Van Zandt lawsuit, which used I don't know if a shell company is the right word necessarily anymore, but one of their businesses, one of their companies, to seek Jennifer Abel's phone contents, and they did so by suing John Doe's, even though they knew who exactly they were trying to sue, and they wanted to do that so that they couldn't fight back, so they didn't have their right to fight back legally against that subpoena. I loved Andy's Popcorn Planet. Yeah, I saw that, yeah. She tried to, at one point, subpoena my personal information, my addresses, my location data for long before I had ever started talking about her lawsuits, my bank account information, all kinds of crazy shit, which she asked for 107 people's data and information, private data and information via social media. And she has tried to somehow suggest that Justin Baldoni should pay for that, even though that was done after his defamation claim was dismissed. And, it was like related to her affirmative claims. So, sorry, I'm trying to fix this up real quick. So she's asking for some bizarre stuff that's not related to the defamation claim. And remember, the judge awarded her attorney's fees and costs related to the motion to dismiss for that one defamation claim in the countersuit. She settled her lawsuit for nothing, and most of her claims were dismissed. So a lot of people get confused because they think, it's part of her lawsuit, like she won something. But no, she did not win any attorney's fees related to her lawsuit. She never proved any of her claims. She dropped it for $0. This is one defamation claim in the countersuit, which had some problems with the pleading deficiencies, the litigation privilege, the fair report privilege was a huge barrier to them actually getting any sort of progress in that defamation claim, and the judge threw it out. So, all right, let me just pull this up, and we'll go through it together. I am going to be back at midnight Eastern. That is in 2.5 hours with Omar, the Tilted Lawyer, so he can give some legal analysis. A reminder, I am not a lawyer. I'm just a nosy observer. So I do my best here, but there are going to be some maybe legal questions that Omar can answer later on that I can't. So no worries there. All right, give me 1 second here, guys, and I'll zoom in to make sure you can read that. Okay. I accidentally blocked Lauren a few weeks ago. It took me what? All right, thanks, I guess. Damn. All right. So this is the introduction. There's only 10 pages of substance here. I know that he gave them a 10-page limit. So this part up here, I'll say the same thing I said about the Lively filing. I don't think they count this table of authorities and the signature page and that kind of thing. So I don't think that's really a problem. Let's see. It says this is anything but a typical fee motion pursuant to California Civil Code Section 47.1. Lively claims that she's entitled to a stunning $7.5 million in attorney's fees for $7,070.20. Wait, okay, sorry. I was like, what do you mean? Okay, 7,070.20 hours billed by no fewer than 82 timekeepers to obtain the dismissal of a single defamation claim at the pleading stage. In contrast, the New York Times is seeking $181,000 in a fee request filed in state court for its motion to dismiss precisely the same defamation claim. Yeah. Of course, Lively could not possibly have spent over 7,000 hours preparing the portion of the motion to dismiss directed to Wayfarer's defamation claim. Rather, to arrive at this extraordinary sum, Lively broadly construes Section 47.1 to cover not only reasonable fees for work necessary to defend Wayfarer's defamation claim, but fees for work on directed to Wayfarer's 8 non-defamation claims and Lively's 15 affirmative claims, which Lively characterizes as inextricably intertwined. So she's basically trying to treat this as an everything bagel, right? So she's trying to ask them to pay for everything, even though she was awarded the fees for one claim. So. Ricardo Holt, thank you for the $2. Hi, lovelies and Miss Lauren. Stay broke. Flake. Okay. All right. It's... However, Lively's affirmative claims, including those for sexual harassment, were unsuccessful. However, Lively's, did that. Either dismissed on summary judgment or voluntarily, and she was therefore not entitled to fees under FIHA or Title VII. Lively, nevertheless, now seeks to recover such fees under the guise of Section 47.1. Lively's fee request is so over-inclusive that it sweeps in fees for researching her own liability for perjury arising from her California CRD claim and her Rule 11 motion, for which the court has already denied fees. And I'll tell you the truth here, like, I know some people aren't going to like this and they'd be like, that's not what it was, but I've had the thought, and I've seen others have the thought, that perhaps they were preparing to defend themselves against the claim that she perjured herself. It's possible. I don't know. I mean, I don't trust these people based on their shady tactics, so I wouldn't be surprised, but it's possible that they were preparing to defend themselves against that claim rather than definitively deciding that she had done something to perjure herself. I don't know. I guess you kind of have to draw your conclusions on that one. All right. So Ellen, who wrote this notes here, perjury arising from CRD complaint, and her Rule 11 motion for which the court has already denied fees. So the judge already said no on the Rule 11 motion to giving her fees, and they asked for them again. So yeah. Let's see. A fee request that appears unreasonably inflated is a special circumstance permitting the trial court to reduce the award or deny one altogether. This is just such a case. Lively fails to establish the reasonableness of rates charged and hours worked. Lively's fee request lacks the requisite evidentiary support. Okay. The starting point is to calculate the lodestar by multiplying reasonable hours by a reasonable hourly rate. And when it comes to the lodestar stuff, we'll talk to Omar about that. He did explain it last time, but just for those of you who missed it, we'll go over that together. Okay. The court then has discretion to exclude time that is excessive, redundant, or otherwise unnecessary. Even where fees are mandatory, the court has broad discretion to adjust the fee downward or deny an unreasonable fee altogether. The fee applicant bears the burden to prove reasonable rates and hours, and inadequate documentation requires a reduction. Lively does not provide billing statements or other records to support her $7.5 million demand, much less allocate fees to her defense of Wayfarer's defamation claim. And I remember watching a video, I don't know if it was Teresa or it might have been Teresa, it might have been Nag, it might have been, I don't know if it was LGA, but who said it was weird or different, not necessarily, not allowed, you know what I mean? But that a lawyer didn't sign off on this stuff, and they had hired someone to go through this with the log that they provided, and it was like not the normal type of thing that you would see, where you would normally see an attorney do this. But all right, anyways, I won't say too much more because I don't want to put the wrong words to what they said, and I'll probably butcher it. So, but that was something that I remember hearing. Okay. Instead, she relies on summaries prepared by financial analyst Diana Kantner that places fees into 3 buckets. Yes, yeah, so financial analyst is who did it. Okay. 1, fees relating exclusively to the Wayfarer action, so defensive costs. 2, fees relating exclusively to the Lively action, offensive costs. And 3, fees relating to both actions, i.e. intertwined. Lively seeks $2.2 million for defensive costs and $5.2 million for inextricably intertwined defensive and offensive work. Kantner's submission deserves limited, if any, weight. Her views on reasonableness reach the ultimate issue and are inadmissible. Okay. Kantner is not an attorney or fee expert, but a consultant on insurance recovery, litigation support, and data analytics. Her experience with legal fees is limited to several occasions on which she served as an attorney fee expert, including some large and complex matters. Kantner does not indicate that she has experience or expertise in evaluating the reasonableness of rates or hours worked, fee matters relating to employment, sexual harassment or defamation claims, or apportionment of fees under Section 47.1 or any other fee-shifting statute. She does not disclose the methodology she applied to segregate work as recoverable, non-recoverable, or inextricably intertwined, or indicate that she reviewed the underlying pleadings or evidence in the Wayfarer or Lively actions or is familiar with the facts giving rise to the parties' competing claims. So it was really a trust me, bro kind of spreadsheet looking thing, right? Like they didn't really explain a lot of the methodology there. Okay. Kantner is fuzzy on whether she was provided with and reviewed original invoices and appears to have relied upon spreadsheets provided to her by counsel, which allegedly reflect the same information provided in the monthly invoices prepared for Miss Lively. So why not just give her the invoices? She admittedly edited descriptions of work to excise privileged and confidential information without demonstrating the experience or expertise to identify such material. Many edits appear haphazard or arbitrary, with some ending mid-sentence. So they don't want to disclose some of the stuff they were charging for. And there was some of the stuff in there that was fucking bogus. Like I said, that she tried to bill for the content creator social media subpoenas, all kinds of weird crap like that. The stuff that it does not relate to the defamation claim defense at all. Okay. Right. But it just sounds like it just looks sketchy. And like I always leave room for there's just something I don't understand, right? So I always leave room for the fact that I'm not an attorney. There might be something about this that I think it doesn't make sense, but that's only because I don't have any experience with the kind of stuff. But this apparently did look very sketchy to a lot of people who do have experience with this kind of thing. And so I'm learning here that I wasn't too far off base, but okay. Wilkie and Manette did not verify the accuracy of the underlying invoices, the spreadsheets provided to Kantner or Kantner's summaries or calculations. Kantner's declaration and summaries lack foundation and should be discounted. Okay, so here they're going to argue that the firm's hourly rates were excessive. They said the reasonable rate is one a reasonable client would pay to litigate the matter effectively. Okay, so when they say that, first reasonable client, look at the weird dumb shit she did with all of those fucking sanctions requests, only to drop her lawsuit on the eve of trial. The weird subpoenas, all the scorched earth litigation that she did. I don't know how reasonable she is, but I don't know if that's the definition that when they say reasonable client, I don't know if the definition that they're looking for is sane. I don't know. Okay. And then they say would pay to litigate the matter effectively. And I keep going back to 10 of her 13 claims being dismissed, 2 of the original 15 being voluntarily dismissed, and then settling the last 3. And it's like the way that her claims were thrown out were so ridiculous. Like they had filed this in California where it was obviously not appropriate to do that. And they had, they probably could have given her better advice as far as using a choice of law. Let's put it that way. And I won't get too far into that because I know there's things I don't understand, but what I do understand is that the way that they litigated this was not effective. Not effective at all. Not effective at all. Now, you would say also that, some have criticized Justin's attorneys and said that they weren't effective in their laying out their claims because a lot of them were dismissed with prejudice. And that's an argument I guess you can make. I think that this was a PR war above all at that point. And I think they did what they had to do. And I think it's exceedingly difficult to even get in front of a jury with a defamation claim because of the privileges she exploited to do this. Because if you say something that's not true and it's in a protected, legal document, you can't be sued for that. So, at least not to my knowledge, not in this kind of situation. Anyways, so a reasonable rate is a reasonable client would pay to litigate the matter effectively while spending no more than necessary, measured against prevailing rates in the community for similar services by lawyers of a reasonably comparable skill, experience, and reputation. And again, they're trying to, the reason I bring up the effectiveness of her lawsuit, even though she was not awarded by the judge attorney's fees related to her dismissed case, she's trying to get them. So important to remember that when you're looking at this figure that she's asking for. She's asking for legal fees related to her claims that were dismissed and her case that was settled, and that wasn't effectively litigated. So even if they were for some reason going to award fees related to that, that would be something to look at because it was just kind of dumb. So, all right. 1 second here, guys. Okay. While an attorney's customary billing rate and fee arrangement with the client may indicate a reasonable rate, a client's agreement to pay an expensive rate does not mean that the rate is reasonable and may be imposed on an opposing party. Biographical information is required for the court to evaluate the reasonableness of an attorney's billing rate, and courts generally deny requests that lack information on a billing attorney's credentials. Okay. So I'm just trying to see if I need to read this parenthetical here. We're good. Lively recognizes that reasonableness requires an assessment of each lawyer's expertise and experience, yet fails to provide biographical information for 71 of the 82 timekeepers. So I remember we did see the biographical info for like Ezra Hudson, Mike Gottlieb, but 82 timekeepers. I don't recall seeing the biographical information for dozens of people. Okay. The $2.4 million in fees billed by timekeepers without biographical information should be deducted from Lively's fee request. Okay. Further, the hourly rates sought by Lively exceed the range typically approved in this district, requiring a reduction of the rates of the 11 other timekeepers. Okay. So that's a question for Omar, because I don't know how that works with the range typically approved in this district. That's the kind of thing we'll ask him about. Okay, we're going on to C. Lively fails to apportion non-recoverable and recoverable fees. She contends that Section 47.1 entitles her to recover fees and costs on both defensive and offensive work that is inextricably intertwined among her successful defense of the Wayfarer action and her unsuccessful prosecution of the Lively action. Fees are generally recoverable only with respect to the claims subject to fee shifting. Okay. Section 47.1b provides that a prevailing defendant in a defamation action brought against the defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in litigation. So a prevailing defendant in a defamation action means the defamation, we're talking about the defamation claim here, right? That was brought against her for making a communication that is privileged under this section. That would be referring to, I guess, her complaints of harassment. Now, does that necessarily mean that she was harassed? No. I would argue that definitely didn't happen. But the reporting it itself has been treated as a protected activity, because even if you're not being entirely truthful, you are protected in making a complaint. And the judge decided to consider this a protected activity. So, and they never went in front of a jury. They never had a trial where they proved that she was malicious in bringing these complaints forth. And so there was really no chance to prove that she did this with malice. And even if they had that chance, it would have been exceedingly difficult to prove that. So, I mean, most people with common sense who read this stuff and look at the evidence and the documents, the video footage, they can tell and make a judgment for themselves. But things in court are different. You can only consider what's brought forth in court and what the judge allows and that kind of thing. Hey, Omar, I just told everyone we would be on together in a couple hours. So I'm saving some of these questions for you. Did she really do all this because she thought Justin insinuated she was fat? In part. In part. I don't think she actually, and if this is just pure speculation on my part, I don't think she actually believed that. I think she was looking for things that she could use to bolster her complaint that was already bogus. So, I don't know. I have a hard time thinking that anyone would actually genuinely feel like they were being fat shamed in that context. And I think I have some experience, just a hunch, you know? So, all right, 1 second. Okay. It's only Lively's defense of count 2 of the Wayfarer complaint is subject to fee shifting under section 47.1. Lively first argues that section 47.1 entitles her to fees incurred for the entire defense of the Wayfarer action based on the use of the term in the litigation. So Mike Gottlieb, in making this argument that they should pay for her entire defense of the entire lawsuit, the countersuit, tried to cherry pick words and ignore the context of those words, saying in the litigation, meaning in the countersuit, in the lawsuit. But they note here, in the litigation, however, must be read with its antecedent, prevailing defendant in any defamation action. Lively cites no authority for the proposition that section 47.1 is any broader and converts every claim in a multi-count complaint or every defense of every co-defendant into recoverable work. So, Lively also seeks to exponentially multiply her fees on the ruse that her defense of Wayfarer's 8 non-defamation claims and the prosecution of the 15 affirmative claims asserted in a Lively action are inextricably intertwined, with fees expended to defend against Wayfarer's defamation claim. Just to answer this question, somebody says, why should he pay for a settled case? I don't think you should pay for any of it, but the judge did order fees related to the countersuit. So the settled case was the Lively action, with all of her original 15 claims being dismissed or dropped. The countersuit, where Wayfarer sued her for defamation, among other things, is a different set of claims. It was their affirmative claims. And so as part of the settlement, they agreed that they would let the judge rule on the 47.1 motion related to the countersuit, and neither side would appeal the decision. And so that's why we're here reading this right now. Now, Omar still thinks there might be a hearing on this. I certainly hope not, but we'll see. We'll see. Okay. Lively also seeks to exponentially multiply her fees. Right, we got that. Lively begins with a remarkable statement that the court is not permitted to apportion the allegedly intertwined claims. Lively is wrong. There's the theme. Fees need not be apportioned when incurred for representation on an issue common to both a cause of action in which fees are proper and one in which they are not allowed. Okay. So that's a question for Omar, is what exactly does that mean, you know? However, a court may apportion fees even where the issues are connected, related, or intertwined. The moving party bears the burden to show that claims are inextricably intertwined. Inextricably intertwined does not mean merely related. Rather, the issues are so interrelated that it would have been impossible to separate them into claims for which fees are properly awarded and claims for which they are not. Lively does not identify any issue common to Wayfarer's defamation claim that would have been impossible to isolate. Right. There's not a lot of explaining going on, right? There's a lot of broad, sweeping claims saying, pay me money. Like, her entire fee motion is a GoFundMe for her attorney's offices. Like, this isn't like something that was well explained or lined out at all, in my opinion. But I always leave a little bit, like I said, a little bit of room for me to, like, not be surprised, just in case there's just something I don't understand. And so far, the vibe that I'm getting from the coverage that I've seen and from what I've read is no, her fee motion was actually like a sweeping declaration of trust me, bro, pay me money. I win, I win, I win. You know, you called my pants sexy or whatever. But there's no real explaining why exactly they should be forced to pay $8 million. So, yeah. Jen says Justin looks amazing compared to how ill he looked at the premiere in the pink suit. He does look good. He and Emily look like they're finding a little more peace these days. I mean, I was happy that they decided to say something, even though it wasn't, you know, they're going to wait a little longer, I guess, until they, you know, say too much. But I was glad they decided to say something and just kind of check in with everybody. You know, Emily, it's got to be hard being Emily in this situation. No matter what Emily does, she's going to get attacked. And so let me take a quick break from this page, right? No matter what Emily does, she's going to get attacked. So Emily's standing by Justin and speaking up in that situation where we know for a fact, based on discovery, Emily was the one who said, fuck it, pull the trigger. She didn't say it like that, but she said, like, pull the trigger on the lawsuit, or like, let's go. We're not going to do this stupid bullshit. They're trying to make us send this statement out. We're going to go ahead and fight. And if you know anything about her and the way she responded in that situation, you know that she stood by Justin this entire time. But people, you know, are going to be critical no matter what. So seeing her stand by Justin in the video, people who don't like them say, oh my God, every abusive man ever, you know, has his wife do this, blah, 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 which is ridiculous, because you shouldn't like generalize and impose your gender bias on everybody and like say that a woman can't stand up for herself and her family and speak for her family and fight for it, right? Or and check your phone. I will in a second. Hey Elsie, how's it going? And then if she hadn't stood by him in that video, they would have said, you know, where's your wife? You know what I mean? So like, no matter what Emily does, she's going to get so much shit. And I've thought about Emily, you know, quite a bit during all this, because I'm like, it must be so hard to be the wife in all this when, you know, people are under the guise of supporting women, as she says, or a fight for women, attacking her and her family at every corner, which is insane. Send me your stream. Oh, yeah. Hold on, give me 1 second. Let me send this link to Elsie. I wish I had some elevator music for you guys, but I don't. That was more like Twilight Zone. I'm going to stop now. All right. Okay. I just sent it. All right, let's keep going. Okay, Lively does not identify any issue common to Wayfarer's defamation claim that would have been impossible to isolate, nor does she explain why her billing records combine fees billed in both the actions without any distinction. Lively's counsel billed work concerning 47.1 fees, damages, and procedural mechanisms in connection with her motion to dismiss. Yet, knowing Lively would be submitting additional briefing seeking fees under 47.1 for the defense of Wayfarer's defamation claim, counsel continued to block bill with no effort to apportion fees between claims. Lively should not be allowed to saddle Wayfarer with millions in fees based on her own failure to properly allocate billing. Further, Section 47.1 applies to the defense of a defamation claim, and Lively provides no authority for the notion that it can be extended to the prosecution of affirmative claims. This court has held that in general, a party cannot recover its legal expenses for prosecuting a counterclaim or third-party claim. The principle on which Lively relies, that fees are recoverable because her affirmative claims are inextricably intertwined with her defense of Wayfarer's defamation claim, applies only where the claims are a mirror image of each other, which requires more than common facts and related legal theories. And this is something we'll talk with Omar about in a couple of hours, just to get a background on that. And some more understanding. I think I understand what they're saying here, where the claims are a mirror image of each other. Like, you have to have like the same. Okay, you know what? I'm not gonna like I said, I'm not a lawyer. I'm not going to muddy the water with that. We're just going to ask Omar about that later on. Sometimes sometimes you guys know when you understand something in your brain, but you don't know how to say it to other people. That's what I get from that. Hey, what's up?
Hey,
How's it going?
how you doing?
Yeah, I'm all right. I'm getting towards the end of this, and then I was gonna.
The end I saw.
Yeah,
I was trying to feed a family.
I mean that
Came in late.
should come second, Elsie.
I know I should get my priorities straight.
Why don't you just feed him some of that white cheddar popcorn he likes so much? Call it a day.
Oh, I hate that. I hate the smell of that thing. Oh, you have no idea, Lauren.
Yeah.
Like no, I get nauseous. Like I get like nausea, and then he does this thing where he doesn't want to wash his hands when he's done,
Mm-hmm.
and then he's like all up in my face, and he grabs my phone, and I'm like,
"Oh no,
sweetie, I love you, and I gave birth to you, but I will take you back for a refund if I knew where to take you back to."
Totally.
Get this popcorn out of. I hate the smell of that cheddar popcorn.
I used to love
so
that stuff.
disgusting.
It's just you eat something too much, and it's like I hate it now.
Oh yeah, you almost become allergic to it because you're like, I don't want to see it again. No, people love that popcorn, and no offense to anybody that loves white cheddar popcorn, but what do you do with your hands when you're done? Just cut them off.
Everybody unsubscribe from Elsie. She doesn't like white cheddar
white cheddar popcorn propaganda.
All right, let me finish this paragraph here, and I'll be down to on one of the last sections, I think. Okay, it says courts also consider the relative degree of success. Okay, well, that's a problem for her, isn't it? Courts also consider the relative degree of success in obtaining results. Defamation was one of 9 claims attacked in Lively's motion to dismiss. Lively asserted 15 affirmative claims against 10 defendants, including 7 claims based on FEHA and Title VII. Lively cannot bootstrap a claim for fees on her failed did not prevail on her FEHA and Title VII claims into a claim for fees available for her defense of Wayfarer's defamation claim. Lively also seeks fees for her Rule 11 and other sanctions motions, even though those motions were collateral to the defamation defense, and the court declined to award fees for the Rule 11 motions. The record does not support a wholesale award of the both matters category. The court should exclude, or at the very least substantially reduce, the $5.2 million billed for both matters and time not tied to the defending the defamation claim. Okay, we go to other reductions apply. Let's see how much longer do I have. I don't have too much longer left in this, but so I'll try not to.
If you want me to finish reading, I can.
Yeah, you want to start here?
Yeah, 1 second. Let me open it on mine so my eyes. I don't lose my eyesight trying to squint.
Yeah, no problem. We're at the bottom.
Read it on here. Okay, hold on. You're on 12.
Bottom of 12. Yep. It's D. Other reductions.
Okay. Other reductions.
Yeah.
And if you hear my kid in the back, pretend you don't hear him.
I always do.
The court must reduce excessive, redundant, or otherwise. Well, that's a given. The court must reduce excessive, redundant, or otherwise unnecessary hours. They cite Hensley 461 USA at 434. Courts also consider whether the case was overstaffed, how much time the attorney spent on particular claims, and whether the hours were reasonably expended. Simultaneously, representation by multiple firms poses substantial risk of task pattern, overconferencing, attorney stacking with multiple attendants at hearings, and excessive research. Just as there can be too many cooks in the kitchen, there can be too many lawyers on the case. The most cursory review of Lively submission shows multiple lawyers at the same hearings, numerous charges for lawyers conferencing, conferring, or strategizing with one another, and to put it mildly, extremely excessive research and online investigation. The court should deny or drastically reduce Lively's fee request to eliminate costs attributable to the overstaffing of the employment matter. Lively's request for 7,020 hours of work is 20 times the number of hours courts have found reasonable in defending similar high-profile defamation actions. 20 times, even those with complicated and underdeveloped legal questions.
Well, hey, I just want to say real quick, I think it's really brave of Blake to try to represent those of us who are upset about inflation in this country by inflating her target.
Like 7,000 hours is insane. That's nuts. That's insane. Even those, like they said, even those with complicated and underdeveloped legal questions. In John's Manville Core, this case is citing the court reduced Wilkie's requested 543,165.70 fees to just 10,000 after finding the request unreasonable, where Wilkie billed 476.6 hours to prosecute a contempt motion. Oh, so Wilkie's just over there cooking the books. That's just what
Oh
they're
my
known
God.
for. Contempt co-counsel handled reasonably in 14.5 hours.
Wait, what case was that in? This was a 2025 case?
Yes, this is 2025. John's Manville Core.
Okay. No, I was like broadly thinking
Yeah.
about what else I've heard of Wilkie from, and I was like, what about the Drake case? It was not the Drake case.
Oh, I mean, they built a crazy amount for that. Probably
really?
just citing, watching. They could probably build millions of hours just by saying they're watching content creators react to Drake and how they're.
Well, they
talking
tried
about
to,
Drake.
they tried to subpoena YouTubers in that one too. Mike
Oh,
Gottlieb,
yeah, for sure.
Mike Gottlieb has a weird fetish for getting people's.
That's his MO.
It's like really
And it's
strange.
funny because I wasn't a content creator at the time, but I watched all those reactions and I lived for every single. And these people were not being paid. It was just what was happening. Drake was being like handed his ass. Every song Kendrick dropped, it demanded a reaction. And Kendrick made it free, for people to play. Drake did as well for people to not get copyrighted.
Yeah.
Here, let me pick this back up. It was reduced to $10,512 after finding the request unreasonable, where Wilkie billed 476 hours to prosecute a contempt motion. Co-counsel handled reasonably in 14.5 hours.
10,000 of 500,000 requested. Can somebody in the chat do the math on that?
Do the math?
Yeah.
What's the percentage? Somebody that's not me. Do the math. Yeah. The type of opaque, the same type of opaque overstaff. And I love that they keep referencing the fact that they overstaffed and did this over lawyering. Like why we bring in multiple lawyers from different firms to come to a hearing one person can come to, just so you could bill it twice. Mm-hmm. Presentation warrants a substantial reduction here. Relatedly, a prevailing party represented by the same counsel as a party not entitled to fees may recover only reasonable fees incurred in the party's own defense. Zintel Holdings LLC versus McLean 209. They cite, it's very long citation. I'm not reading all that. Applicant must allocate fees.
Someone in your chat is asking, did they bill Wayfarer for subpoena on all the content creators? Yes, they did.
Yes, they did. You already got to that, right?
I'm super happy about that.
Yeah. Can you imagine?
Yeah.
Can you imagine?
This lady tried to figure out where I was every day for the past year, and she wants to bill someone else for it. Like, what the fuck?
Absolutely insane. She's never been well. Like, and I don't know why we haven't committed her yet. Like, she's never been okay. We need to have her committed, but that's neither here nor there. Allocate fees. It incurred between. I'm right here. I guess you can see.
Where are you?
I'm right below the citation. In between, between its defense of the claim for which fees are available and the defense of a jointly represented party. Lively does not allocate fees between Lively and Reynolds, failing even to separate fees attributable to Reynolds' separate motion to dismiss. Cantoner's, oh my God, that Cantoner lady, like, this is another trust me bro situation. I'm sure you already got to the Cantoner woman.
Yeah, we went to that. Yep. Mm-hmm.
It's another trust me bro thing. Cantoner summarizes all. You would do that.
Well, I mean, these things made me want to scream as well, so I understand.
Right. While you eat a tub of blueberry, no, you cannot come in the camera. You can wave your hand. They can see your hand. That's the most chill, filthy blueberry hands.
How's it going?
Go hang out with your dad. Lively does not allocate fees. You can have my phone. I should just go to the studio. I don't know why I'm doing this from the living room. Lively does not allocate fees.
Give me your phone.
I know he's taking the phone. Take the phone and go hang out with dad. Here, go quickly. Take the phone and go, please. I'm begging.
Did you play Words with Friends? I'll play with you.
No, he can't. Run away. Do not go play with Lauren. Go hang out with your dad. Or I'm gonna go leave. I'm gonna leave here. Claims. I'm sorry, guys. It defends. Does that say? Oh, between its defense of claims for which fees are available and the defense of a jointly represented party. I'm picking it up again. Lively does not allocate fees between Lively and Reynolds, failing even to separate fees attributable to Reynolds' separate motion to dismiss. Cantona summaries also reflect fees relating to allegations against Sloan and the Times.
How did
All
they
third-party
justify
fees.
that shit?
Say again.
How did they justify that shit? Like, how do you? I guess they didn't, right?
They didn't. That's what they didn't. They didn't even give justification for anything. They just threw the numbers together and said we can't do anything because we just the cases were too mixed together. That's literally all they gave us.
Right.
Okay. Reductions may apply for vague entries, block billing, duplications, excessive staffing, unrelated work, and work that should have been performed by more junior professionals. Gonzalez versus Fresh Start Printing Corps.
I'm sorry, what?
Fresh Start.
Okay, that is not. I was not looking, and that is not what I thought you said. Okay. Omar says, I tried so hard to get subpoenaed. I left text message bombs for Lively and team just in case. That's true. He left me some very interesting text messages and emails just in case our communications ever got subpoenaed. Not sure why they would, but he did that.
No, but I always did. You know how in our text I would always put, "Hey guys, what do we do when this gets subpoenaed?" I was like, if this ever gets subpoenaed, that might be the funniest part, is the fact that we were preparing to be subpoenaed. I would always every now and again throw in our group chat, I'm like, if this gets subpoenaed, I didn't mean it.
Well, anytime I texted Andy, I said something outrageous. And I started my text to Andy with "Your Honor," just in case.
That is so funny. Can you imagine a judge actually reading that?
Yeah, actually, I would hang my head in shame, but yeah. Your Honor, please don't shake your gavel at me.
That is funny.
Lauren, they didn't justify anything at all. They made a wild spreadsheet and called it a day. Well, that's basically what I do at my day job. So, whatever.
Literally. They didn't even bother, honestly. I mean, the exhibits I'm seeing here from Wayfarer, it looks a little bit better than what they gave us.
I haven't even opened
at least Wayfarer has... I opened 1 and 4. 4 has like dates of like, who got paid what. Ezra, I mean, we already knew Ezra gets $1,600 an hour. Isn't that insane? Right. And then, there are some other people who got that at least.
$1,600 an hour. You think she could answer my email in a timely fashion?
No, she's too busy. No. You can afford her.
No, I can't, but the person who's subpoenaing me can. So.
Who's subpoenaed can. And now they built it to Wayfarer.
Yeah. Oh I think you were at the courthouse last time I was there. I avoided Ezra Hudson like the plague.
I said, no, I was surprised. She said hi to me when I said hi. I don't think she realized it was me. I think it took her a minute to realize it was me because I had never been to the court before.
Yeah.
Because Sigrid talked for a long time, but that's her job. But Ezra said hi, shook my hand and everything before realizing, wait, that's that bitch.
I came out of the courthouse after we were done, and I was waiting. I was like, "Where's Elsie? She hasn't come out yet." But you must have gone by me or something, because I go over there and you're there with your selfie stick, like a spearfishing rod, running after people.
I was running, like I was being, like I stole something. I was being chased.
I was just gonna watch. All right.
No, because remember when we came out, we weren't sure if the lawyers would come out from this side or that side. We weren't sure if they would come out from the main gates or the back gate. So I was hanging around the back gate for like a good minute in case, because I didn't want to miss anybody. Then turns out they all went the other route. But then somebody was like, "Oh, Sigrid is talking to the girl from not the LA Times, from what's her name? The girl who had the glasses." She ended up sitting. Remember, I was sitting next to you.
The LA Times, Lauren.
I think it was LA Times. Yes, her.
Yeah, she's cool. Yeah.
So she was talking to what do you call it? I'm gonna send you a screenshot. She was talking. I just want to say,
I know that a lot of media can be very biased and they report in a way that's frustrating. Lauren has always been very good. She covers all the New York court cases, like the Diddy trial and all that. And I feel like she's always done a really good job. I'm a fan of her reporting for sure.
Yeah, she was super sweet.
I feel like I'm always complaining about reporters. I never them to say when somebody does a good job. So here's somebody who did a good job. Lauren does a good job. So.
Yeah, I mean, could it be that you're biased because her name is Lauren?
No, if anything, that would make me hate her.
I'm joking. I figured as much. No, but she was very sweet. Even when I went up to talk to Sigrid, it was me, her, and then the TMZ girl. Jesus, I still have nightmares about how horrible that interaction was. And so the TMZ girl kept trying to cut like in front of me and Lauren. And so Lauren asked her question, and then the girl was gonna cut me again. And Lauren was like, no. Pretty much like, I go. And I was like, thank you.
Yeah.
No, but she was super sweet. But that was my only interaction with her. But that, I mean, it was enough to be like a good first impression, considering she didn't have to like, you know, be nice or anything. Yeah. And she was taking hella notes. I was like, what are you writing?
Oh yeah.
I mean, maybe she could hear Ellen because she was in front of Ellen technically. But those of us who were sitting behind, we couldn't hear. When Ellen was talking, I could barely
Ellen was quiet. She was quiet.
Yeah. You couldn't hear anything in there.
I tried. I remember trying to go say, like, introduce myself and say hi to her before cameras came over, because I was like, I don't want to make you talk on the camera, because I didn't know how she felt about it. So I was just like, hi. I wanted to introduce myself, and then she was like, I think we already met. I was like, oh shit.
She is very I don't know how to describe her exactly. She's very like quiet, but also like her very cut and short. Like what is the word I'm looking for? Like she's very short and sweet in her interactions. She's not draggy. She doesn't drag things out. If you ask her a question, if it can be answered,
she's brief, I would say.
Very, brief is brief is a great word. She's very brief. She's not here for a long time. She's here for a good time.
Yeah, there's nothing wrong with that. I mean, some people just like that. I didn't know what to expect. Obviously, you only see Brian really make appearances, and of course Kevin when he came to talk to us. But like, I've never heard from his other attorneys before, so I was like, I don't want to intrude on her space, but at the same time, I'll just go say hi and see what happens. She's like, we already met, so I was like, I guess I must have said hi to her or something at the last court hearing, and I just don't remember it.
Yeah.
So, yeah.
No, I think she was very sweet. I mean, she was still brief and everything, but she was still very sweet. If once we do, I guess Judge Lyman responds to this, there has to be a hearing. They're gonna have to do a hearing for this. Are you going?
That's what Omar said. I think he wants to wipe his hands and be like, nah, fuck this.
You think he's just gonna make a decision without a hearing?
Get the fuck out of my face. Like, I don't know.
Wait, you think he would just make a decision, no hearing?
I do. Yeah.
I think hearing. Okay, this is how I feel. Before Blake and her people came back with that, oh my God, like, what do you want us to do? Do you want us to explain what exactly do you want from us? I thought for sure hearing. Yeah. But then he was like, you know what? I don't have time for all of this. Just give me all you got, like, and you don't get to come back for anything else. And then you get 2 weeks, and Wayfarer gets 2 weeks to respond. I was like, oh, maybe now no more hearing, because it's like anything you have to say about this, I want to hear it now.
In 10 pages, yeah.
Right. So maybe there might be no more cause or need for hearing. But I think after he sees Wayfarer's response and he's going to rule on something, the least he could do is give us a trip to New York. Like,
I don't need any more.
Just give us one more.
I'm so good.
I do. I want us to get together one last time and like actually put a bow on this thing.
We just go to Miami for that. It's fine.
We could stay. I mean, I could stay. You guys could come over.
Yeah.
We could just do it in Miami.
That's what I'm saying.
The math came back.
House. It's fine.
The math came back on the $10,000 or 554. And it is 0.0189%. Is
it really?
That sounds super small.
Yeah, I guess.
I feel like that sounds super small.
If it were 10%, would be 10% of 100,000, right? So for 500,000, it's divided by 5. So that wouldn't it be like 5%? I'm stupid with math.
No, it wouldn't be 5. It wouldn't be 5, but that number looks super small. Okay, hold on.
It wouldn't be 5%. Never mind. That's way overplayed. Okay.
5% would be super small. Wait, did I just start coding? What the heck did I do? I clicked something and it looks like I'm about to code in C++. Oh no, honey. That's not what I'm trying to do ever. Okay.
Yeah, I'm not doing this right. I'm just gonna give up on the math. I don't care.
No, I'm gonna do it. Hold on, because now I'm curious.
Where did you leave off? So let me read a little bit more.
Oh, right. Repeatedly. Nope. Hold on.
You read that thing about the painting corp. Okay.
Oh yes, I'm on like at the top of. You can pick it up like bottom of 13 going into 14. Like reductions may apply.
Reductions may apply for vague entries, block billing, duplication, excessive staffing, unrelated work, and work that should have been performed by more junior professionals. Okay. That reminds me, like, more junior professionals, like some people should be handed certain tasks instead of their superiors, sort of like Jamie Heath shouldn't have been made to bring Blake Lively toilet paper, but that's apparently her MO, so maybe she made her senior attorneys do all that work.
Rude. That was so disgusting of her. In
a lesson, for instance, the court identified block billing, vague entries, disproportionate post-award work, and duplicative associate time, and imposed a 30% reduction in hours. Okay. The records reflect extensive internal conferences, overlapping review, and parallel work streams across firms. A percentage reduction may be used as a practical means of trimming fat from a fee application. Time entries for work on non-defamation claims include discovery, media statements, reports, and appearances, social media tagging, digital campaign fact gathering, damage experts, and punitive damages. Those entries are not self-evidently defensive of the defamation claim against Ms. Lively. The court should exclude without limitation fees for non-defamation claims, work for other Lively side defendants, that seems obvious to me, and post-dismissal work other than the fee motion. Reduce the claimed rates, trim excessive and duplicative hours, disallow unrecoverable expenses, and require any request for later invoice fees to be made by a separate supported application. Okay. Finally, plaintiff may not recover fees on fees. For example, the time spent litigating plaintiff's fee application. So fees on fees are the attorney's fees for writing the fee motion. So, which are available only when permitted by the unmistakably clear terms of the applicable statute or contractual provision. Right. Lively's costs and expenses should be sharply reduced. She seeks a whopping over $500,000 in costs and expenses without providing evidence to substantiate the costs or attribute them to tasks covered by Section 47.1. They really just threw that out there and then didn't explain it at all. Courts deny requests for costs without supporting invoices. Okay. Let's see. Lively seeks substantial sums relating to experts, even though no experts were designated in the Wayfarer action. How could they be? They didn't get very far. Section 47.1 does not expressly authorize expert fees, consultant fees, or damages analysis expenses. Absent explicit authorization, the term costs is construed narrowly and does not include expert or consultant fees. Further, Lively cited experts, Colletta and Humphreys, opined on Lively's alleged reputational harm and not on a subject relevant to Wayfarer's claim. So that was her affirmative claim. There was no expert opinion on the Wayfarer defamation claim. Lively also seeks over $170,000 in costs charged by GBX Holdings LLC on behalf of one of Lively's retained experts for impressions and damages work. Okay. In sum, Lively fails to meet her burden to present credible evidence showing that the fees and costs she seeks to recover are reasonable, and accordingly, her fee motion should be denied in its entirety. At minimum, the court should substantially reduce the request using as a benchmark the $181,622.70 the New York Times sought after securing dismissal of count 2 on its separate motion to dismiss, the same outcome Lively achieved. So that's it. I think, we have to go through the, I'll take a look at the exhibits here. Sorry, I didn't even see what you were doing.
Guys, don't tell me. This ginger ale is very expensive and very good.
Oh.
You have to get every last drop out of it. You work for or at Fever Tree. Hook a girl up.
Hold on.
It's too expensive. Oh, Lauren, I got the math back.
Oh, there are 13 exhibits. What was the math?
It's literally 1.9, pretty much 1.94%. That makes sense.
Yeah. Okay.
Yeah, 1.94.
That sounds way more right than 5 or 50 or whatever.
Yeah, for sure. April Love, you like Fever Tree too? I'm telling you, you guys, because they have like a grapefruit, they have a ginger beer, ginger ale, they have like a tonic water. They have all the best stuff, and it's supposed to be used as a mixer. That's why it's so tiny. But I don't. I just drink it as like a regular like Canada Dry ginger ale, which is why I'm broke. That's funny, Deborah. Oh, did you see the exhibits that I was talking about where you pull up exhibit 4, you could see the hours, the billable hour. Like Wayfarer actually took the time to give us the dates. I don't know why Blake's team just didn't do that.
Not sure.
Is the 26 pages?
This is one, sorry. That's the New York
No,
Times.
yeah.
Sorry.
So you want 4.
2,
You want attachment 4. That's the only one that's available.
3, 4.
Oh, I guess all of them are available now.
Yeah.
I will look through all of them, but yeah, if you pull up 4, you see the dates and how much who got. And oh, actually, there's more. 2A. Who are these people? They were for sure Abidor, Pascal, Adams, Kasia, Adam, Jack, Autumn. That's a name. Adams, Jack, Autumn. Wow. You work for half an hour. Wait, who is this? Oh, Serene Armani. $9,000. $190,000. Who? What? Who the hell is Juliet, and why is she getting 200,000? Okay, somebody's getting $800,000. What
a lot
the
of these
hell is
exhibits, they just look like they're sectioned out parts of the Lively's spreadsheets.
Yeah.
So like this one is just related to the sanctions motions. For example, this is exhibit 5.
They spent. Did you read the part where they spent over $1 million? I think 1.7 million or something like that on just sanctions.
This one says sanctions motions $905,852.30, but that's, I don't know what that, if it's including everything or not, because this is just
that was insane.
But that is nutty.
Like, does Blake know she didn't have to do this?
I'm
like
sure.
This was optional, completely optional, and she went for it.
Mm-hmm.
She committed to the bid. She committed really hard to the bid. She said, "I'm not giving up."
See if I find anything else in here that's not
out of town taxi services. Oh, I'm so annoyed. Yeah. Airplane, train. Oh,
here's one that's example of vague entries.
Which exhibit?
Attention to workflow.
Jesus, are you kidding me?
Attention to workflow, $14,000. Where can I get a job paying attention to other people's workflow for $14,000?
Wilkie Manat and Far, whatever it's called, and Fart.
Unfortunately, I don't have time to learn how to schmooze with big law people, so I'm just gonna not do that.
Wilkie Manat and Fart.
So this is they put $200,000 here. Just about.
It's so interesting seeing some of these names for the first time. Like, who are you?
Some of these guys are just like probably juniors at the firm or something.
For sure, like associates.
Yeah.
I mean, if you're billing $200,000 to defend a stupid motion that definitely needs to be rewritten, this bill definitely needs to be taken back to the drawing board.
This one says not Wayfarer case, lively affirmative action, Jones Works, New York Times, Sloan, $300,000.
Just a cool 300.
Yeah.
Cool. Just I got that one. Send me that bill.
9.
I'll take care of that one.
Yeah. Okay. Sure.
I got it.
See. I don't really know what exactly this one is. Let's share this tab. Let me pull up her declaration again. She'll explain, I guess, what it is.
Thank you guys for joining. If you're just joining, make sure to like and share. Hit the thumbs up. I always feel weird when I have to do this little spiel. Hit the like button, guys. It helps us out a lot.
5, 6, 8, 9. Ms. Lively also seeks fees for non-legal or business-oriented work, including advice concerning media communications. They want her to pay. They want him to pay for her PR or something. Media communications, press coverage, social media reports, and client media appearances. Dude, what? Exhibit 9 identifies representative entries.
Oh, she's
on March 6th, Ms. Hudson recorded an entry to strategize regarding client media appearances. You're not her. She's paying Leslie Sloan for that. What are you doing? She recorded time to advise regarding legal issues related to a media statement. Okay. Well, I mean, okay. I don't like it, but okay. And on June 18th,
I don't love it.
Yeah, but I mean, I won't say it's outside of the realm of possibility that she did that. I just don't think they should have to pay for it. You know what I mean? On June 18th, she recorded time to review and analyze media and social media reports and analysis. But that's not
our problem.
Why are you hiring experts if you're having... Okay. Notably, Ms. Lively previously took the position that media advice is not attorney work because it constitutes a business rather than legal function.
Why is Ms. Lively getting to decide these things?
I don't know, but I guess the way that she positioned herself on Brian's media appearances does not help her in regards to arguing that her lawyers should be paid for media-related stuff.
True.
So, all right, so that's Exhibit 9.
Clerical administrative. Yeah. Oh, and then for 10, Ms. Lively also seeks fees for clerical or administrative work, including filing documents in counsel's internal document management system, iManage, indexing, pleadings, what the heck? Updating trackers, calendaring, preparing binders and e-binders, distributing filings, managing services list, and book reading.
Attorneys' fees are fucking weird sometimes, man.
It is very weird.
I'm probably not going to pay somebody to do that.
And then there's like when the other exhibit, you can see like whenever my godly took a train or took a taxi or took a car service or whatever. I'm like, are you shitting me?
Oh man.
Like, oh my God. Like if you're an attorney, you just can be lying to your clients. Hey, I'm having this steak dinner, but I'm thinking about you while I have this steak dinner. Billable hours. Honestly. Like I'm sent from iPhone, Ellen Garofalo, billable hours. I was having a drink, but I was sending stuff from my iPhone on your behalf. Billable hours.
After work drinks, $4,000.
Billable hours. Honestly, I really need to become one. Steak dinner, a little potato gratin on the side. Billable.
That was Exhibit 10.
Oh my God, yeah. 11. Ms. Lively seeks attorney's fees for travel time. Yeah. Untethered to any identified proceeding or event related to the defense of the defamation claim. 47.5 hours and 55,000. What the wait. $55,000 in travel related entries? Where did y'all go? Wait, where did they go?
Wait, why does DC to LA? Wait, why are they charging from DC to LA?
Wait. What did they go to DC for?
No, from DC to LA.
From DC to LA.
So some of them probably live in DC, but like, why are you?
How the hell is that our problem?
Oh, fucking no.
Miss Hudson recorded. Okay, hold on. Okay, Miss Hudson recorded 10 hours or 11,000. Was she just out here booking first class? Like, yeah, I'm not paying for this. 11,610 in a blog that included travel from New York to LA. Social media commentary calls with unidentified persons. Of course, you're gonna call it. Wait, what social media commentary did Ezra Hudson give for $11,000 in travel money?
And they think that we make money off this stuff. Like
calls with unidentified persons, multiple litigation work streams on February 4th. Miss Rosa recorded 4.5 hours. That's fine. Then DC to LA, $6,000. Wait, was she booking Delta One? Because she's like, this is insane. Because how was that $6,000?
I don't know, dude. It's crazy.
Miss Cantoner's billing summary shows that Miss Lively's counsel began billing work concerning 47.1 fees and procedural Oh wait, did she go to DC to I was gonna say, what's her name? Victoria Burke. Did they meet in DC for something, or I'm tripping?
I don't think so. That was in New York.
Because what the hell is this DC thing? Because we never. Who was in DC?
I think DC to LA. The only
Taylor Swift's lawyer.
The only thing I can think of is when she tried to get protected information from the firm, from Friedman's firm, which is located in California. And so that they would be trying to charge for that is the only thing I can think of. I can't confirm that, obviously, but like that's the only thing I can think of is the lawyers traveling to LA for that hearing where they argued in front of the judge on whether or not she should be able to see Brian's communication with the clients, their firm's communication with the clients. That's the only thing I can think of. So,
Jesus Christ. I want to be a lawyer and just book a flight first class and just say, you know what, I have to go figure out your social media strategy. You pay me later. What?
No, what is 12?
Let's
Exhibit
see.
12, A through G with descriptions. Okay.
12 to 8
The declaration
to G.
schedules purport to summarize the expenses.
Oh, that's the 500,000.
Okay.
That's the
Descriptions
593,000 extra.
Local
The
meals.
largest category. Jesus Christ. The largest category in that within that 539,000 is 374,000 in experts.
Yeah.
They literally experts and consultants. Yeah. Expenses includes a single $173,000 charge described only as GBX Holdings. That's Blake's thing.
Yeah.
As well as generally described as I'm sorry, but this is giving very much Rico. Somebody is cooking the shit out of these books. Because what?
Ms. Lively also seeks $134,519.65 in computer research expenses for Westlaw, Lexis, Bloomberg, Pacer. She could have just gotten them from me. And similar charges that generally do not identify the research topic or proceeding to which they relate. And she does not provide invoices, nor does she provide the firms at Westlaw and Lexis fee arrangements or otherwise explain how Ms. Cantor arrived at that requested amount. Well, alrighty then. That's a lot. Let me look at this last.
Insanity.
Order granting petitioners attorney's fees in part, denying attorney's fees in part. Okay. This is like an example from another case, I think.
Uh-huh.
Yeah.
I really got to become a lawyer because these fees.
I think becoming a lawyer is not cheap, but then you get to bill with the ass. So
I guess you can be like, hey, I feel like eating a Dubai chocolate, but I know a good lawyer who can give me an answer about your case. So I'm going to Dubai real quick. Billable hours.
Yeah, all right.
Get some chocolate while I'm there.
Yeah.
This is insane. Ezra, 5 hours of travel, DC to LA, $6,000. I'm trying to understand what you do in 5 hours for $6,000.
No idea, dude.
Is that including her hours? As in, because it's 6,000 and she bills like what, 1,600 an hour. So is she saying like she worked, say, 3 hours of the flight or 4 hours of the flight, and the flight was like a first class $2,000 trip, then the car to get her from airport to hotel or airport to her house?
I don't know how they do these things, but that sounds
honestly. This is insane, guys.
All right. I'm going to be back here at midnight Eastern if you want to join me and Omar. But
it depends on the boy.
Yeah. I'm going to call it for now. Take a little break for an hour, eat something, take a shower maybe, and then I'll be back here. So I'll let you know if what the link is if you want to join us.
Are you going to bill?
Totally. only for the time I spend in the bathroom.
You should definitely bill for all of the things you just said. Showering, maybe eating. Yeah, bill for every single thing.
I'll bill.
I'm going to go
YouTube support.
Yeah, no, honestly, I think I'm going to bill for putting my kid to sleep because I'll be thinking about Blake while I do that. So I think that's billable. I'm going to try to put him to sleep. He's still in there with his dad. I can hear him making noise.
All right, guys, just don't forget to hit the like button for us. We appreciate that. It helps us out a lot. And I will see you guys shortly. Maybe Elsie will be with us. We're not sure yet.
Maybe. Or I could actually go from my phone, but I will probably be in the dark, like in the bedroom. So it would be Elsie after. Oh, that sounds so bad.
Yeah, it does.
It would be like Elsie really after dark or something. You guys will probably see my eyes and my teeth. I'll look like a little raccoon in the dark. Because if I turn the light on, then my kid will be awake. And if I record from my studio, then he's going to come in there like he often does. So thank you guys for joining us. We appreciate you. And everybody become a lawyer so you can bill.
I'm sending you over to my friend Sarah. People on my stream are going to be sent to Sarah Axolotl is what she calls her channel now.
Oh, Sarah's still live?
Yeah, she used to be Yarn and Order. She's still live right now. So I'm sending you guys over there to her. And I will talk to you guys very soon. Thank you.
Au revoir.
Bye.